Hi, my name is Malini Vijaykumar. I'm a lawyer at Nelligan Law in Ottawa, and today I'm going to provide you some information about what your rights might be if you've recently been affected by a restructuring or a resource action. The first thing you should be aware of is that there is a statute in Ontario called the Employment Standards Act, which provides certain minimum protections for employees if they are losing their job, whether it's due to a restructuring, a resource action, or just an individual termination. The ESA provides a couple of entitlements. First, it provides the right to be paid all accrued and unpaid wages as of the last day worked. So that's any salary, bonus, commissions, etc., that you may have earned as of your last day worked, as well as all accrued and unused vacation pay. The ESA also provides a right to receive minimal notice of your termination or pay instead of that notice. And that notice protection is typically 1 week's notice per year of employment, up to a maximum of 8 weeks. The ESA also provides for statutory severance, which is an additional 1 year payment per year of employment, up to a maximum of 26 weeks. Only some employees get statutory severance under the ESA. You have to be working at your company for 5 years or more, and your company's payroll has to be $2.5 million or above. Finally, if your termination is part of a large group restructuring or resource action that has resulted in the termination of at least 50 employees at one time, there are additional notice protections that are set out in the Act. However, these are only the minimal protections under Ontario employment law, and you could be entitled to a lot more than these minimums, depending on your situation. We're going to talk a little bit more about that shortly. Now we're going to talk about what your entitlements might be under your employment contract or under what we call the common law of employment. So let's start with your employment contract. If your employment contract has a termination section, it may provide specific entitlements that are greater than the ESA minimums I just talked about. That could be a particular formula for your termination or severance pay, or it could simply be the ESA minimums plus a certain amount above that. Your employment contract may also set out that you have to sign a release in exchange to get paid your contractual entitlements. If your employer is offering you your contractual entitlement only and asking for a release, don't sign anything until you've had the chance to have that contract reviewed by a lawyer. The reason for that is even if your contract says that you are entitled to a particular sum, that provision in your contract might actually be unenforceable at law. And when we say unenforceable, that typically tends to advantage employees and cost employers in terms of liability. So don't worry if the advice you get is that your employment contract's termination clause is unenforceable. That might mean that you are entitled to even more generous protections. That's where we come to the topic of the common law and reasonable notice of termination at common law. If your employment contract either doesn't have a termination clause, or if the termination clause is unenforceable, or even if you have no written employment contract whatsoever, you could be entitled to something called reasonable notice of your termination at common law. Common law is another term for judge made law through legal decisions and precedents. And in Ontario, the reasonable notice entitlement at common law generally tends to range around 4 or 5 weeks per year of service with the company. So if you've worked for 5 years, for example, you might be entitled to somewhere between 4 to 6 months at common law. There are a number of factors that affect this entitlement. They are called Bardolph factors. They include things like your age, the seniority of your position, the length of your service with the company, and in general, how easy or difficult it might be for you to find comparable new employment. Reasonable notice of termination at common law is meant to essentially act as a bridge between the end of one job and the start of the next comparable job. Other factors that might affect your reasonable notice entitlement include things like whether you were actively recruited from stable employment in order to join this company. If that's the case, you might be entitled to even more than that four-ish week per year entitlement. And another factor that is often considered is the presence of non compete or non solicit clauses in your employment contract, which again put certain limits on you when it comes time for you to try and find a new job. So, if you're wondering what your entitlement is, whether it's what's in your contract or potentially greater, again, it's really a good idea to talk to legal counsel about what your rights might be. So, we've talked about the length of the reasonable notice period, but what are you actually entitled to in terms of pay in lieu of reasonable notice? Well, there is case law at the Supreme Court of Canada that says that you are entitled to all of the elements of your compensation during this time period. So, for example, if you are terminated, let's say April 1st, and every year there is a bonus that gets paid out to employees in June. And let's say that your reasonable notice entitlement is 6 months. Because the bonus would come payable within that 6 month period, you may have an entitlement to the payment of that bonus over and above your base salary. Similarly, if you are earning money based on any kind of variable performance targets, something akin to commissions, then if those payments would come due during the reasonable notice period, you may be entitled to an amount that approximates what you could have earned in that notice period had the employer given you working notice of your termination instead of simply terminating you and then paying you out your notice entitlements in lieu. All that to say is if you get an offer from your employer on termination and the offer is just for base salary during the reasonable notice period, take it to a legal professional to get looked at because you may be entitled to more than just your base salary. You may be entitled to things like benefits continuation, bonus payments, commission or other variable incentive payments throughout the notice period, and those can be quite significant. So we've talked about the concept of reasonable notice of termination at common law and the fact that depending on your age, your length of service with the company, and other factors, it might approximate somewhere around 4 weeks or a month per year of service. However, there's also an important concept that we have to discuss called the duty to mitigate. The duty to mitigate means that if you're terminated from your job, you have the duty at law to try and look for comparable new work. You don't have to take any offer that's provided to you. If you're getting job offers that are very significantly at a lower compensation, lower title, etc., than what you're used to, then you're not under a legal obligation to accept that. However, if you receive if you are out there looking for new work and you receive a job offer that is comparable to the position, the title, the compensation that you held with your old employer, then you may have an obligation to accept that job offer. And if you do, then that can offset the company's entitlement to you for reasonable notice of termination. So let's get into an example. Let's say you've worked for your company for 10 years. Let's say that the assessment of your reasonable notice entitlement is perhaps 12 months or pay in lieu of 12 months notice of termination. You would have a duty to start looking for new work, sending out resumes, applying to jobs, however is customary for your field. And let's say that at month 3, you find a position that has compensation of about 90%, 95% of what you were making at your old job. The title is pretty comparable, the level of responsibility is pretty similar. uh, you would either take that job offer, in which case that would offset the remainder of the 12-month entitlement that your old company has to you for reasonable notice pay. Or if you don't take that offer, then your former employer, who you may be negotiating with for a better severance package, your former employer may be able to say, well, hold on, I don't think this person has discharged their duty to mitigate. So I'm going to discount their entitlement down from 12 months to something lesser than that. Again, this is a topic that can be relatively complicated to get your head around. So, if you are in severance negotiations with your employer and the topic of mitigation is coming up, you should definitely seek legal advice on what your obligations are if you haven't already. All right, so we've just covered the topic of what we think of colloquially as severance. So whether it's under your contract, under the Employment Standards Act, and or under common law, which is what we've just been discussing. But there could be other entitlements that you have a right to because of your termination or the manner of your termination specifically. Under Ontario law, it is true that employees can be terminated without cause as long as they are paid their entitlements that are appropriate to them. Again, whether that's under their contract, statute, or the common law. But in some cases, the actual termination decision itself or the behavior or the treatment that led up to the termination might be unlawful. Those are situations where, for example, if you were facing discrimination leading up to your termination, if you were terminated in retaliation or what we call reprisal for asserting your rights to a safe and non discriminatory workplace under human rights law, or if there was bad faith and additional unlawful conduct in the course of your termination. For example, maybe your employer didn't submit your record of employment to Service Canada and blocked your entitlement to get EI. Or maybe they just failed to pay you your minimal statutory entitlements altogether, which, by the way, those have to be paid regardless of whether you sign a release or not. Maybe your employer has withheld the wages that you've earned for the days that you've worked leading up to your last day of employment. All of those kinds of behaviors are what we call additional independent legal wrongs, aside from any breach of the obligation to pay out proper notice and severance on a termination. And those can entitle you to additional damages. For example, if you've been discriminated against in your workplace leading up to your termination, if you asked for a disability accommodation and then you were terminated abruptly after that, if there were discriminatory or otherwise insensitive or callous comments or treatment around your termination, you could be entitled to additional damages. And these might be paid on a non taxable basis. These are what we call general damages. So they don't count as employment income for tax purposes. They are, in fact, a separate and non taxable sum. Again, if you have any questions about the treatment that you've experienced leading up to your termination, or you want to know if maybe you have a right to one of these types of general damages, talk to a lawyer and let's see what we can do. All right, so we've just been talking about what your entitlements might be at law flowing from your termination. But you might want to know, what do I actually do in the termination meeting itself? How am I supposed to handle these communications with my employer, at least in the first initial stages? So, your termination meeting might happen in person. It might be a Teams or Zoom meeting. That really depends on a number of things, whether you work in the office, whether the office is reachable for you. That will be determined by the employer, basically, the method of your termination meeting. You might get a letter sent to you either before the termination meeting, during the meeting, or immediately after. And that letter should set out all the logistical items to do with the end of employment. So things like returning company property, handing over the laptop, terminating any accesses to software and things like that. And then it should also contain a section talking about the payments that you would receive. So, what you're entitled to under the Employment Standards Act, which again would be paid out to you automatically, regardless of whether you sign a release or not. And then additional conditional entitlements. that they would ask for a signed release in exchange for those additional payments. And again, it's very, very important that you not sign or agree to anything in terms of a release or any payments in exchange for a release at the time of the termination meeting. Just hear what's being said. Take notes. You would have the right to be able to take notes at the same time of the meeting. And if you have any questions about the logistical items like return of property, you can feel free to ask those. But in general, trying to negotiate your termination package on the spot is typically not the best idea for a couple of reasons. First, you may not know what your full entitlements are at law. And so if you provide a counter offer during the termination meeting, it actually might be less than your true entitlements, and you might be boxing yourself in unnecessarily. The other reason why it's not a good idea to try and negotiate in the meeting itself is because it's a very high stress time. And these documents are typically very lengthy, filled with dense legal language intended to protect the company and not you. That's why we recommend that you speak to a lawyer about your rights, but also bring these documents to a meeting with a lawyer so that the lawyer can review them and point out anything that would be unfair or unlawful for you to sign in the release. The release is essentially a promise that you are not going to come after the company for any type of legal claim whatsoever. And so that's the kind of document that you really want to have reviewed by an experienced professional to make sure that you're not signing away any rights that you don't have to be. So, in sum, just hear your employer out during the termination meeting, take notes as best you can. If there are any documents that are in your employer's possession that would be helpful for you in terms of negotiating your entitlements. So, again, things like your employment contract, any benefits documents, any documents to do with a bonus plan or other incentive payment, things like that. Let your employer know that you will be forwarding those documents to your personal email. If your employer objects to this, tell them that you will need copies of these documents as they will enable you to assess your rights and entitlements with legal counsel. Now that all this has happened, what do you do next? And how exactly do you reach out to a lawyer and begin the process of setting up a consultation? Well, if you call our office, our intake line is 613-238-8080. You'll be connected to our employment group's intake clerk who will take your initial information, walk you through what we have to do in terms of setting up a file. So, for example, our intake clerk may ask you for the names of other parties that are involved, perhaps for the name of your manager. This is so that we can do something called a conflict check so that we can ensure that we're not acting for the other side in this matter, either unknowingly or through inadvertence. So once we do the conflict check and we ensure that we're free and clear to act for you, our intake clerk can run you through what the fees would be for our consultation, what is typically meant by a retainer, and what you would have to bring to your initial meeting with a lawyer. That initial meeting can take place either in person or by video call, whichever is most comfortable to you. From that point, you will sit down with a lawyer on our team who will talk to you about what your entitlements are. They will review your contract. They will go through your common law entitlements with you if those apply. They can also go through any kind of non compete or non solicit limitation that you might have and answer any questions in general that you may have about the manner of your termination and its legality. Then we'll talk about a retainer. So at our firm, the way we do retainers is typically via a deposit. The amount of that deposit goes into our trust account, and it does not get drawn down from until we send you an invoice for our time and services. So if you have a consultation and you provide a retainer, and then we provide services for you in terms of a negotiation of a better severance package, at the end of the day, if there's money remaining in the retainer in our trust account, that would get refunded back to you. Another thing we typically do is when we are negotiating a severance package, we will typically include and ask for reimbursement of legal fees. So if we get such a reimbursement as part of the negotiated and improved package, then that would go through our trust account, and any money that you have paid the firm up to that reimbursement amount would be refunded back to you. All right, that's a lot of information. I hope that it's been helpful to you. If you don't retain anything else from this video, just remember this. Don't sign or agree to anything in the moment while you're under stress. Take what is given to you back to a legal professional for review and advice. Don't worry if you're not dotting all the I's and crossing all the T's during what can be a very, very stressful termination meeting. Come to us. Let us take some of that off of your shoulders. We will know how to write to your employer, how to request any documents and evidence that might be helpful to you, but that might not be in your possession. And we will know how to handle the communications with the employer going forward. So just receive whatever it is that you've been given. And your very next step, hopefully, should be calling us for advice so that we can walk you through what has to happen next. Again, I hope this has been helpful. If you have any questions about the information in this presentation, please give us a call at 613-238-8080.